Ready? Start. Section 149 has no application where the court fee due on the plain as per the valuation of the suit is fully paid, but subsequently it is found that a larger amount is due to the plaintiff. For example, if the plaintiff values the suit at rupees 2 lakhs and the court fee payable is rupees 20,000 and the plaintiff pays a court fee of rupees 10,000 on his request, time for payment of balance of rupees 10,000 can be extended by the court at its discretion under section 149 CPC. But where the claim was rupees 2 lakhs and full court fee of rupees 2 lakhs was paid at the time of institution of the suit, the question of permitting the plaintiff to pay deficit court fee at that stage does not arise, as no court fee becomes payable at that stage. In this case, the appellant could have either himself measured the work done by him or secured the information from the respondent. The appellant has neither made out a right under a statute nor any fiduciary relationship nor any right in equity by establishing that except by calling upon the defendants in the suit to render accounts, it is not possible for him to get relief. The appellant has sued for rupees 2 lakhs and paid court fee thereon. Nothing prevented him from suing for rupees 5 lakh 33,000. In para 5 of the plaint, he states that the total value of work done by him was rupees 10 lakh. He knew that he had been paid only rupees 4 lakh. He also knew the value of material supplied by the employer. On an careful reading of the aforesaid paragraphs of the election petition contained in Annexure 1 of the writ petition, it is clear that election petition contains an advocate statement of all material facts on which the allegations of not only illegality in counting of votes were founded, but specific allegations of manipulation and fraud played by returning officer while counting of votes were leveled with material particulars. Not only this, but the petitioner has also adduced voluminous evidence to support the allegations leveled in the election petition in respect of aforesaid illegalities and manipulations in counting of votes by entering himself in witness box and by examining his counting agent. The aforesaid version of election petition was also supported by other candidates by filing their affidavits before the election tribunal, which clearly established that the petitioner had adduced sufficient evidence affording a good ground for believing that manipulation was done and fraud was played while counting of votes by returning officer. Therefore, in my opinion, the only way to decide the dispute and to do complete justice between the parties was an order for recounting of votes. From perusal of impugned judgment and order passed by the election tribunal, it appears that the statement of petitioner and his agent in respect of manipulation in counting of votes has been rejected without any cogent reason. It appears that while dealing with issue, the election tribunal, under wrong notion of law, has illegally assumed that the petitioner was required to prove his allegations made in the election petition beyond reasonable doubt, whereas in view of legal position enunciated by Honorable Apex Court and this court from time to time as indicated herein before, such standard of proof for inspection of ballot papers for the purpose of recounting of votes is not at all necessary. The election petitioner was required merely to adduce such evidence on the basis of which allegations could be prima facie established, affording good ground for believing that there has been mistake or illegality or manipulation in counting of votes, and further on the basis of such evidence court or tribunal trying the election petition could be prima facie satisfied for directing inspection of ballot papers or recounting of votes. A distinction between prima facie opinion and concluded opinion was required to be kept in mind, but while rejecting the prayer for recount of votes, in my opinion, the election tribunal has proceeded completely on wrong notion of law and rejected prayer for recount of votes on the ground that the petitioner has failed to prove his case. In this connection, it is to be noted that when the allegations in the petition were not vague or indefinite or frivolous, rather they were very specific in terms and supported by oral evidence adduced before the election tribunal, in as much as affidavits of other candidates, there was sufficient material before the election tribunal affording good ground to believe that illegality or manipulation was done in counting. Thus, even though we set aside the order, we do not think it proper to go into the question on merits and to pass a final order on that application. This course, we think, will serve the interest of justice and prejudice neither. Source is 3P Legal RHC exercise number 11. Words are 806 and speed is 100.